Well, good morning and welcome to today's webinar, Your Action Plan, 10 Things Every Dealership Manager Should Know with David Buchsbaum with Fisher & Phillips. I'm Nicole and I'm happy to be moderating this first live FIADA webinar in our new 2014 series. Please know that the webinar is being recorded and will be available after the presentation on our YouTube channel later this week. During the presentation, your phone lines have been muted to eliminate any background. Feel free to submit questions using the chat icon at the top of your screen. We'll have an opportunity for questions at the end of the presentation. And FIADA is pleased to welcome today's speaker, David Buchsbaum. David is a partner with Fisher & Phillips office. His practice involves representation of management in all areas of labor and employment law. A significant portion of his practice focuses on emphasizing issues related to minimum wage, overtime, timekeeping, and wage payment requirements. As a key member of the dealership practice group, David is experienced in advising and representing automobile dealerships. David is AV, peer review rated by Martindale-Hubbell, and was selected for inclusion in the Best Lawyers in America 2013. Has been recognized as a 2013 top-rated lawyer in labor and employment by American Lawyer Media, 13 South Florida top lawyer by South Florida Legal Guide. Today, David will discuss some of the best practices to avoid liability, as well as 10 hot action items for 2014 and ways to be a better manager. David, thank you so much for joining us.
Despite the technical difficulties, it's still a pleasure for me to have the opportunity to speak with everybody and to impart some of the knowledge gained in my years of practice, employment law, and especially dealerships throughout the state of Florida. And so here at the beginning of a new year is a great opportunity to speak to everyone and really hit the highlights of what all managers and owners need to know about employment law and dealing with employees. And so I've got the list of 10 items. You through the key bits of information that you need to know, starting with number one, how to hire good employees, all the way down through how to terminate, and give you some basic knowledge to try and keep yourself out of the situation of being sued. So the presentations to managers, certainly owners have a vested interest, but for managers is, why does it matter to me?
I have a code to turn off the off, but I can't do it when I'm
liability.
Which is a real
% of named individual supervisors or owners as defendants. And that is so not just the company is being sued as a defendant in a legal action, but an individual manager is personally named. And a lot of times there can be joint representation where the company pays the attorney's fees involved, but that's not always the case. And there may be some situations, depending upon the facts alleged, that an individual manager will have to pay out of pocket to retain their own legal counsel. And so obviously it's in every manager's best interest to take appropriate actions in their dealings with employees to avoid that risk and minimize the opportunities that an employee would have to sue you. There's also loss of career. I mean, even if you personally don't get sued, if you've made some bad decisions that result in liability to the company, to the dealership, you may find yourself out of work. So those are two really good reasons as part of number one. Reason number two is more practical, and that's simply that unhappy employees are unproductive employees. That business and that manage a business, you want to make money and you need employees to assist you in doing that. And the more effective your employees are, hopefully the more money you can make. The less productive and less effective they are could affect your bottom line. And there's also, if you're making bad decisions causing people to leave, you've got to start over with the whole hiring process of searching for a new employee, going through the hiring process, going through the training process before they're up to speed. And there's a lot of what I call both hard and and soft costs involved in doing that. So where do we start? Well, obviously the first place to start is the hiring process. And there are numerous laws that employers have to deal with throughout the employment process, and good place to address those is with hiring. And so we have Title VII of the Civil Rights Act, which is the federal law that prohibits discrimination and harassment on the basis of gender, race, national origin, religion, and several other protected categories. Most people have, at a minimum, heard of Title VII. There's also the Age Discrimination in Employment Act, which protects employees that are 40 years old or older. There's the Americans with Disabilities Act, which protects individuals that have disabilities. We'll talk a little bit about that under another one of the topics. And keep in mind, there's also the Florida Civil Rights Act, which basically mirrors the protections of those three federal laws, as well as creating some other protected categories. And when we're dealing with hiring, we also have to be aware of the Fair Credit Reporting Act, which I'll touch on momentarily, the Immigration Reform and Control Act, and also new hire reporting laws. And there is an obligation for all employers in Florida to notify the state of all new hires. That primarily is, if there are individuals that are delinquent on paying child support in Florida and in other states, there's a way of determining who their employers are. So if you're going to start hiring, you've got to know what you're looking for. And so you've got to ask yourself that question before you even start the first job interview. Are you looking for previous experience? Are you looking for job knowledge for a particular job? Is appearance important? Personality, enthusiasm, technical expertise? All of these, none of these. And I'm not saying these are the only things to look for or the exclusive ones. But you've got to have an idea of what it is that you're looking for, because if you don't, you're going to go down a path of possibly making a bad hiring decision. And it is always easier from a liability standpoint to decide not to hire someone than to hire them and quickly realize that it was a mistake and then have to go through the process of firing them. So if you sit down and put some time into thinking about what exactly you're looking for, it's going to make the hiring process go more smoothly, because when and when you are interviewing people, you can be matching them against the criteria that you've set up in your mind as to what it is you need. First step in a hiring procedure should be a completed application. If you don't require potential employees to fill out an application, I would encourage you to do so. I mean, there's no magical form. You can get applications anywhere. You can request an application from me. You do want to make sure you're getting it from a good source so that it has the proper questions on there that you want to ask, and does not have questions on the application that you do not want to ask. But you always want to have an employee fill out an application, even if they're going to provide a job resume, because the application is going to ask for specific information that you want. A resume is more a piece of creative writing. If they want to submit a resume with the application, that's fine, but it should never be a substitute. And all applicants should be required to fill out that job application in its entirety. Having gotten that job application, you want to make sure that you review it before step 2, which is a thorough interview. And the reason you want to review the job application is questions in your mind as to issues that you need to follow up on. If there are gaps in employment, in that section where you're asking about their employment history, you want to ask them about those gaps, find out why they weren't working, where they were, what they were doing. I mean, you certainly, why they're not working, there may not, but it's certainly things that you want to ask. If we're looking at declining pay, someone leaving one job that pays them a higher amount to go to a job with a lower amount, you want to follow up and ask questions why. Things on there that were omitted that they just didn't answer. Those are all opportunities to ask questions during the interview process. As I said, that's step 2. And so you bring them in, you fill in any gaps, and get to know them. And to do a proper, thorough interview, you want to make sure that the applicant is doing most of the talking. We refer to this as the 80-20 rule. It should be talking, communicating 80% of the time, with you only doing talking 20% of the time. If it's the reverse, you may be doing a great job trying to sell them on why they want to work for you, losing the opportunity to evaluate whether this is someone that you want working for you. So the interview process is also the opportunity to see how that applicant matches up with what you've set as those goals, those things that you're looking for in an employee. If you have an applicant that you feel strongly about, that you have a positive feeling about, you want to make sure that you check references. You may not get any information. If you're calling any prior employers that are clients of mine, they're probably not going to tell you anything. But not everybody has been instructed not to answer those questions, and you may get someone that will honestly convey some meaningful information about that individual. It's certainly worth the phone call or two to see what you can find out. You also want to make sure that you do a criminal records check and a DMV check, and especially where we are dealerships and we have employees that are frequently going to be driving with customers and moving vehicles around the lot, taking people out for test drives. We want to check their DMV record. We want to make sure they are insurable under our garage policy. Now, specifically with respect to criminal records, it's important to understand that this has been a hot-button issue with the last year or so. And the EEOC has come out and told employers that they cannot automatically disqualify someone from employment just because of their. So we can't merely look at their criminal record, say, oh, they were convicted, I'm not going to hire them. Where does that leave us? Just so we can avoid feedback. So what do we do based on this guidance? Well, it doesn't mean we can't consider criminal records at all. It just means we have to consider specific facets of it. What was the nature of the offense? How far back in time was the person convicted? What's the nature of the job for which he or she is applying? And so we've got to look at those factors and then ask ourselves, does this person's criminal record render him or her unsuitable for the job? And in some cases, it may. If you're hiring someone that's going to have access to your customers' confidential information, Social Security numbers, bank information, things of that sort, and they've been convicted of identity theft and fraud in the past, that may be a real risk that we want to avoid taking. However, if we're looking at someone that was convicted of marijuana possession 15 years ago and has had a clean record since, we may not consider that to be any bar to hiring them. But we've got to look at those various factors and analyze things on a case-by-case basis. Also, when we're talking about criminal records checks and motor vehicle checks, we also have to be aware of the Fair Credit Reporting Act, and I get typo in that. I apologize. I thought we had corrected that. That should be Reporting Act. And this is a law that's been around for many years, and still many employers are unaware of it. And the law regards consumer reports, but in the statute it defines consumer reports extremely broadly to include driving records, criminal records, credit reports, and many other reports that come from third parties that are often requested by employers or potential employers. And so what you need to understand is any time that you bring a third party to obtain any type of background information on a potential employee or an employee, the Fair Credit Reporting Act comes into play. So if you are going directly to the state of Florida to check a motor vehicle background, we're not using a credit reporting agent. You're doing that yourself. Don't worry about the Fair Credit Reporting Act. But if you're using a third party who is then going to the state of Florida or to any other source to obtain this information, they are a credit reporting agency who are obtaining a credit report on that applicant. So what does the law require? Well, before you can run a credit report on someone, you've got to get prior written disclosure from that applicant or employee. You've also got to get an authorization from that applicant or employee. And those two things can be on the same form. That's usually part of either applicant packet that they have to fill out when filling out your application. You've got to make certain certifications to the consumer reporting agency that you're using. And importantly, if you are going to take an adverse action with respect to an applicant, we're talking about a decision not to hire, based on information obtained from that credit report, you've got to give written notice to them before taking the adverse action, putting them on notice of what you're about to do, and giving them an opportunity to correct that information if, in fact, it was reported improperly or wrongly. And then you have to, again, give written notice once you've actually made that adverse action decision. And so this is where a lot of employers run afoul because they don't realize that they're covered by this act, and they make decisions, background checks, without complying with all the requisites of the law. And it can lead to lawsuits that can be costly and also include attorney's fees for a prevailing plaintiff. So we want to try and avoid that. As we move along the process, we should be drug testing employees, and we'll talk about that again a little bit later. They should get a formal job offer. Once you've made the hire, you've got to fill out an I-9 form, and that's the immigration form. They're not difficult to fill out, but there are specific pieces of information that need to be put in specific places, and it needs to be filled out in its entirety. And failure to do that in the event of an audit by the Department of Homeland Security could be costly because the penalties can be anywhere from $110 to $1,100 per form, for mistaken entries, record-keeping mistakes, and obviously the higher penalties for failure to fill out the form timely or for failure to fill out the I-9 form at all. You want to make sure, especially for salespeople or anybody that's on a commission pay plan, that they have a written pay plan. It's simply a bad idea, and I speak from experience in representing dealerships, to just make pay plans based on verbal communications, because that's where miscommunications occur, and that opens the door for misrepresentations by employees once they no longer work for you, claiming that wasn't the deal and you didn't pay them what they should. If you're putting it down clearly in writing, there can be no disputing later on what the deal is, and little opportunity for litigation over whether someone was paid properly. So it's a really good idea for commissioned employees to have a written pay plan, and one that spells out in some detail exactly how the person is going to be paid. Because keep in mind, if there's litigation, it goes to a jury. That jury may have no experience working for dealerships or dealership pay plans at all. So you want to make sure that the pay plan lays everything out so that an individual that has no knowledge of your business can understand exactly how that employee was intended to be paid. And last and importantly, you want to onboard that employee. You want to orient them to your business. You want to make sure you have a formal introductory period during which you are monitoring them more closely, because while you still can't discriminate, even in hiring or after 1 day of employment, as a practical matter, it is easier to justify terminating an employee for bad performance within the first 90 days than it is after they've worked for you for 9 years. So we want to make sure that we give them the tools and skills and information needed so that they can succeed, but that we also monitor them closely during that introductory period. So some quick hypotheticals. In your experience shows you that females do a better accounting job than males. Bob applies for one of your positions, and you politely deny his request and tell him he's better suited for jobs that require lifting, etc. Are there any risks? And hopefully, there's no one on this call that thinks that's okay. That is classic discrimination by making assumptions that certain jobs are more applicable for one gender over the other. If there are legitimate reasons why for lifting requirements for a job that may make it likely suited for men than women, that's fine. Legitimate job requirements are what they are, but you couldn't tell a female that she could not apply for a job like that. She would have to be given the opportunity to answer whether or not she can perform those physical requirements. We don't want to make assumptions in terms of the hiring process. Assumptions very quickly lead to litigation. In our second hypothetical, you're advertising for salespeople, and one of the applicants is female. You don't think she can handle the job, and even if she could, she might be offended by talk in the showroom. So you tell her she's not going to be a good fit. Again, the question would be, are there any risks on that? Well, of course there are, because again, we are wading into the area of making assumptions about.
Ella está trabajando, ¿quién la procura?
We don't want to assume whether someone can or cannot perform the functions of the job. We want to explain to them job requires, plus whether they can handle it. They may have no problem. The other phrase in this hypothetical is that she might be offended by talk in the showroom. Well, that leads to a problem, because if you're aware showroom talk that could be offensive to a female and you're not doing anything about it, you're probably not doing what you have to in order to avoid harassment claims, which is there shouldn't be any talk on your showroom floor that would be offensive to anybody of a particular gender, race, national origin, or anything of the sort. Number two, on our what we need to know, and I get questions a lot of times. People will say, well, it's a right to work state, or if it's at will employment, I can fire them for any reason. And so there are some misconceptions about those two terms. And so to address those just very quickly, right to work merely means that an employee cannot be compelled to join a union. That's it. That's all right to work means. Because in some states, if a business is unionized, all employees of that business must join the union. So Florida being a right to work state means even if a business is unionized, that no one can be compelled to pay dues and join that union, even if that union may be representing their interests. Employment at will simply means that an employer may terminate an employee for a good reason, a bad reason, or no reason at all, so long as it's not an unlawful reason. And by the same token, it means an employee can leave at any time, with or without notice, for any reason. No one can be compelled to work for any term unless it's pursuant to a contract. But that unlawful reason throws some caveats into what you can do. Because we can't just say, I can fire someone for any reason, we're at will. Because there are a number of unlawful reasons. And most of these are protected categories that come out of Title VII, the ADA, which is the Age Discrimination in Employment Act, or the Americans with Disabilities Act, the ADA. We have protected categories: race, religion, national origin, gender, pregnancy, age, disability, citizenship status, service member status, and with each passing year there seems to be more and more protections. Florida also has a Private Whistleblower Act, so you can't terminate an employee because they're complaining that their employer is engaged in unlawful activity. Concerted activity relates to the National Labor Relations Act. You can't terminate an employee because they're engaging in protected concerted activity, protected under that statute. So there are a lot of reasons that prevent you from just terminating someone just because you want to do it. Some at-will myths, and we hear these a lot. When an employer wants to terminate an employee. Well, things are just aren't working out. We've decided to make some changes. I don't have to give you a reason. The reality is, no, you don't have to give anybody a reason, but you never want to give someone a false reason. So if you're telling someone that their position has been eliminated and you plan on going out and advertising to fill that position, and they find out about it and believe that they were discriminated against, a jury will be instructed that they can infer from the fact that you gave an untruthful reason to that employee that you were covering up for an awful motive. So while it is difficult as a manager to terminate employees and to tell them that they haven't been doing a good job, if you're lying to employees go and sugarcoating the reasons why you're letting them go, you're doing a disservice to the dealership. You need to be honest, because if you're not, it can come back to bite you in the event of a lawsuit. At-will employment really means that if you terminate someone or make other employment decisions related to them, you've got to be prepared to explain of exactly what you did and why you did it. That you simply need to be prepared in the event that someone claims that you were motivated by a discriminatory animus and have your legitimate, non-discriminatory, non-retaliatory reason justifying that decision. So you've got to ask yourself when you're making termination decisions, how comfortable are you with that? If you're terminating an employee, how comfortable are you justifying to a jury why you did that? And if you're not comfortable with how you would justify that to a jury, you might want to reconsider whether termination is appropriate in that particular instance. Another hypothetical, we have Frank, who's African American, and for about a year since he was hired, he's failed to consistently sell the minimum number of cars each month. You've spoken to him about it, but it's not your style to write him up. Then you have a big argument on the sales floor and you terminate him for poor performance. Are there any risks with this? Well, I mean, yes and no. Hopefully, where we're terminating for objective reasons like failure to perform in terms of units sold, we have reports that can be generated that would show that this employee consistently failed to meet those unit goals. And ideally, if we're terminating this employee for that reason, we have other employees that are meeting the goals, and we can show the differences between the successful salespeople and Frank. As a employment defense attorney, I would say I don't like the fact that there would be no write-ups in this person's file over the course of a year. Write-ups are great evidence to have to, number one, try and settle a case or make a plaintiff's attorney or try and convince a plaintiff's attorney to just go away or to mediate a better resolution, evidence that justifies the legitimate reason. And that's why it shouldn't be an issue of whether writing someone up is your style or not, the good management practice that you want to follow. Because that way you'll be prepared to justify that decision if you have to. In our next hypothetical, we have a salesperson of Middle Eastern descent who expresses an interest in a sales manager position, and we tell him that we think he can do the job, but we can't promote him because with the recent tensions in the Middle East, we just don't think customers and other salespeople would trust him working on their deals. Any risks in that one? That one should be pretty obvious. I mean, that's almost outright discrimination based on national origin. If someone is qualified for the job, we cannot simply refuse to hire them because we don't think that people will trust them. We are making assumptions. Number one, and number two, we cannot condone other employees and customers discriminating against our employees based on their national origin or on any other protected category. Number three, a topic that's near and dear to my heart because I do a lot of wage and hour compliance work, is how to properly pay your employees. For all of us running businesses here in Florida, it's important to remember that Florida remains the number one hotbed nationally for lawsuits under the Federal Fair Labor Standards Act. And the Fair Labor Standards Act is the federal law that requires payment of minimum wage and of overtime. So when we're talking about wage and hour laws, primarily we are talking about the FLSA. Now, if we're talking about national filings, the Southern District of Florida, South Florida accounts for 16% of all filings nationwide. Add in the Middle District, which is another 8% of filings nationwide, and you'll see that the state of Florida accounts for a quarter of all of these cases filed each year across the United States. Just let that number sink in. We have some of the most aggressive plaintiffs' attorneys bringing wage and hour cases, a lot of them nuisance cases, but they're filing them. And if you are not making every effort to ensure that you're in compliance with minimum wage and overtime requirements, you're basically opening the door to be extorted in what I often refer to as legalized extortion in these cases, because it is almost inevitably cheaper to settle and make it go away than what it would cost to try the case and take the chance that you may not prevail. Common violations that I see under the FLSA are misclassification issues. and that is where an employer is not paying overtime to employees that should be getting overtime. One common misconception that I still see is paying someone a salary does not automatically make them exempt. There are white-collar exemptions that one of the requirements is to be paid on a salary basis, but there are other specific job duties requirements. And if the employee does not meet those specific job duties requirements, paying them a salary does not get you out from having to pay overtime. All it does is open the door for you to get sued, not just for the amount of overtime that you should have paid, but for a doubling of that, because the law provides for liquidated damages. Also, at dealerships, if you are a business that sells retail cars, you're very fortunate because there is an overtime exemption for salespeople, parts people, and mechanics. But you've got to make sure that they're performing the right job duties to fall under and meet the requirements for those overtime exemptions. And if you're not, again, you're opening the door to litigation. Another common violation that I see are poor record keeping. Bad time records means easy lawsuits. And that is, unless your employees are completely exempt, and one of these white-collar exemptions from minimum wage, overtime, and record keeping, you've got to maintain accurate time records. So salespeople who formally exempt from overtime are not exempt from minimum wage. So we have to have accurate time records to make sure that they're earning enough to cover the minimum wage. If you're not requiring these non-overtime exempt employees to maintain accurate time records, again, you make it real easy for someone to claim later on that they worked more hours than they were compensated for. Another common violation is off-the-clock claims, and that's where employees are able to legitimately claim that they were told to start working before they clocked in or told to continue working after they clocked out because they needed to finish their job, but their employer didn't want to have to. Can't do that. Don't want to have any opportunity for an employee to be able to claim they were asked or required to work off the clock. And overtime calculation errors. Overtime is if you have employees that are not exempt from overtime, it's based on a work week. Your work week is whatever 7-day cycle you as the employer have set. Overtime is based on that weekly standard. Even if your pay period is biweekly, you do not get to blend your hours over the 2-week period. The employee works 44 hours in the first week and 36 hours in the second week. While that may average out to 40 in each week, those 4 hours in the first week are entitled to an overtime premium. Also, a common mistake that we see is where employees are not exempt from overtime. They're paid hourly, but they also get additional pays, whether it be spiffs, performance bonuses, or other compensation that's tied to the quantity or quality of work. All of that is considered part of their compensation that has to be factored into the proper overtime rate. So while you may be paying them hourly with time and a half on the hourly, if they're getting non-exempt employees are getting spiffs and bonuses, they need to be getting overtime on those spiffs and bonuses as well. And there are specific ways to go about calculating how that is to be done. And a last common violation that we see are independent contractor status claims, and that's where employers think that free with an individual, that person will be an independent contractor, and they'll be paid on a 1099, and then we don't have to worry about all these minimum wage and overtime and other specific requirements as to whether someone is an employee or an independent contractor. Their agreement to that doesn't matter if they challenge it later on and a court determines that those factors are not met. This is an area of increased scrutiny by not only the federal government but also state government. So make sure that if you are treating any individuals as independent contractors, that you are comfortable that they are meeting the test for that or that you are comfortable with the risk. So a hypothetical here, we've just learned from payroll that Patty Porter worked overtime last week without permission. So we tell our payroll person, maybe unauthorized. You plan to meet with Patty, tell her she can't get her work done in 8 hours, she should punch out at 8 hours and then finish her work. Problem solved, right? Hopefully not. Hopefully, after listening to me just a minute ago, everyone recognizes you can't do that. First of all, even if overtime is unauthorized, if we know that an employee has worked overtime, we have to pay for those hours. We can discipline them for working unauthorized overtime. We can terminate them if they've been warned in the past and continue to work unauthorized overtime, but we cannot simply choose not to pay that overtime. Also, the second part of this hypothetical opens the door to an off-the-clock claim, because we're basically telling her, clock out after 8 hours, but working to get your work done. We can't do that. If Patty Porter is unable to get the work done in 8 hours and we don't want to pay for overtime, then maybe we need to discipline Patty Porter for job performance and ultimately replace Patty Porter and hire someone else that can be more efficient and get the job done. But we cannot play games with the payroll. We cannot have them work off the clock, and we cannot choose not to pay them for legitimately worked overtime. Our next top issue, what you need to know, is how to avoid harassment problems. Again, we talked about some of these laws before, Title VII, the ADA, and the ADEA, but when we're dealing with harassment, there's also the possibility of assault and battery claims, false imprisonment claims if someone is not permitted to leave when they want to leave, invasion of privacy claims, and even a host of negligence claims, such as negligent hiring, negligent retention, if a coworker was a known risk to create a potential problem to an employee. So we know, and as an attorney, we can easily define, what is harassment? Well, the legal definition is offensive or unwelcome language or conduct that is severe or pervasive. And that's a great definition for us attorneys. It gives us a lot of grounds to defend our clients when a former employee or current employee claims by arguing that it wasn't severe enough or pervasive enough. You don't want to be making your decisions day to day and dealing with your employees using that as your standard. So all of you should have a no harassment policy. You should also have handbooks, which is the perfect place to contain this policy. If you don't have a handbook, I can always talk with you later as to why it's a good idea, but you need to have a no harassment policy, because that's going to establish the dealership's commitment to maintain a lawful workplace. It's going to protect all of the employees of the dealership, including the managers. And your policy is going to require compliance by all employees and managers. And the reason you want this is because having a policy can help create an affirmative defense in the event that someone claims harassment and they never complained about it pursuant to your policy. They never put you on notice. So we want to have this policy. But as I said, we don't want the standard of the policy to simply be that legal requirement. We want the standard to set a much, much lower tolerance for what is acceptable. We want to encourage all employees to act professionally at all times, and that includes managers, that includes owners. Everyone should be acting professionally in the workplace, and so it should cover anything that's offensive, anything that's related to a protected category. And if our standard is professionalism, and we're holding everyone to that standard, we're never going to have to worry about over whether conduct was subjectively or objectively offensive or severe or pervasive. So, I would encourage all business owners to make sure that they have a good, strong, no harassment policy that is distributed to all employees. Basis for harassment, it tracks along that we talked about with hiring decisions. All of those protected categories, all of those statutes that protect against discrimination also protect against harassment.
Okay.
While a dealership is not liable for consensual conduct between coworkers, it does become liable if a manager knew or should have known of offensive conduct or language and failed to stop it. And so, we cannot turn a blind eye to anything that we see or hear or that is reported to us. We need to have our finger on the pulse of our place and on the conduct and communications between coworkers. A type of, and there's some, their line muted. If you could hit *6 just to avoid the background noise. Hypothetical salespersons kill time by joking with each other. You've heard them joke about sex, race, age, religion, amongst other things. You've heard them jokingly call an employee a terrorist. And you've even joined in from time to time, but no one's ever complained. So you don't have to worry about that, right? Unfortunately, that's not the case. Just because no one's complained yet doesn't mean that someone's not going to. It's simply unprofessional behavior. If it sounds like I'm taking the fun out of the workplace, unfortunately I am. And the reason that I say that I am and that I feel the need to do so is because I've seen all of these lawsuits, and I've seen businesses, both large and small, individually or family-owned businesses, deal with the ending against claims of discrimination and harassment. They're no fun. It takes away from your business. And in some cases, the cost of defending yourself might even put you out of business. And at that point, you may be looking back and think, okay, well, the joking that we had wasn't really worth it. And so it's better to understand that at the outset and try and avoid it. Even if employees go along with it, I've seen it all the time. Later on, they will claim that they felt they had to. They felt, if they didn't, they'd lose their job. But it bothered them, and now they're suffering from severe depression. We don't want to give anybody the opportunity for claims. Make sure this type of conversation and discussion has no place in your business. Susie's young and energetic, and you think she'd make a great sales for her to the sales floor. However, she struggles to meet her minimum sales for the first month. You tell her that she can improve sales if she focuses on men, stays away from women and couples who may feel threatened by her good looks. Any risks with that? Of course there are. I mean, we're telling a female employee, just to target men. We're basically implying that she should use her good looks to make sales, but she shouldn't bother trying to sell to women and couples. And that can certainly be perceived by that employee as harassing conduct. Again, it all goes back to just making assumptions as to what someone's going to be good at or bad at based on one of their protected traits. We don't want to do that. Where's the line? There is no right line. You say hello sometimes to a receptionist. You offer to bring her lunch. You sit at her table. Is that a problem? Probably not. As we start going down this list, you ask her about her personal life, or you tell her about your personal life. Now we're starting to cross the line into unprofessional conduct and behavior that shouldn't be going on between managers and employees, and probably not between even coworkers. Off-color comments and jokes, commenting on clothing, and you can see as this progresses, you may start looking at it and cringing as to how this would look to a jury. Keep in mind that any of your conduct between yourselves and employees, you may down the road have to justify to a jury of that employee's peers as to what you said and why you said it. If it's anything that you would not be comfortable repeating to your spouse, your mother, or your children, you probably don't want to be saying it or doing it. Guidelines: keep your personal feelings to yourself. Don't tell jokes or stories involving age, race, sex, religion, or any other protected category. Don't socialize with subordinates outside of work. It just opens the door for problems. I've seen it time and again. And of course, take every complaint seriously. You never want to blow off an employee if they're complaining about either your conduct or the conduct of any other coworkers. When should you take action as a manager? Well, obviously, if an employee makes a complaint, you need to follow up on it. But it goes beyond that. Even if they mention a problem, or a customer reports a problem, or you even hear a rumor, or someone tells it to you secondhand, or it's something you observed, if you are on notice of any potentially harassing behavior, you need to address it right away. How should you do that? Well, interview the person that's complaining about the conduct, find out if there are any witnesses, talk with them, interview the accused employee, If they're being accused of harassing someone, you want to get their side of things. And once you have all the information, you can determine the appropriate corrective action. Maybe it's termination, maybe it's simply a warning, maybe it's nothing. And of course, and the last one's most important, you want to document everything that you've done along the way, because in the event of litigation, that documentation is going to be proof of the effort that you as the employer took to do the right thing. Number 5, how to deal with employee medical problems. I get these questions from clients all the time. And yes, I will agree, medical absences can be disruptive, they can be frustrating, they are, without a doubt, sometimes abused by employees, but a lot of times they are legitimate. And so, we can't just treat them as nuisances. When we're dealing with medical absences, there's generally 3 laws that could come into play. The Workers' Compensation Act in Florida, the Federal Family Medical Leave Act, and the Age Discrimination. That should be the Americans with Disabilities Act. And also the Florida Civil Rights Act, which protects disabled employees. With respect to workers' comp, most people are aware of workers' comp. It kicks in if an employee is injured on the job. It provides an entitlement for medical treatment and to have that paid for by their employer. And it can provide for supplemental pay if the employee is out of work for more than 7 days. The dealership under the workers' comp law in Florida does not have to hold. What the law does prohibit is not take an adverse action. You cannot terminate an employee simply because they have filed a workers' comp claim or threatened to file a workers' comp claim. So that's the retaliation portion. But you don't necessarily have to guarantee reemployment at some undetermined date when they might be able to return to work. Typically, we're going to suggest that you do keep their job open for a short period to recuperate, but as that recuperation period drags on or is for an extended period of time, you may simply have to replace that person. Under workers' comp, that's not going to be an issue. Dealership does not have to continue to pay an employee's medical insurance if you provide insurance to that employee under the. That is the Family and Medical Leave Act, and I understand, for most members of the FIADA, you're not going to have to deal with the Family and Medical Leave Act. It's a federal law that applies to employers that have 50 or more employees in 20 or more calendar weeks in the current or prior calendar year. But that magic number is 50. If you have under 50 employees, we do not need to worry about FMLA, and there is no Florida equivalent with a lower threshold. There may be county ordinance that provide medical leave that you might need to check with to see if you're covered. But for those few, if there are any on the line, just to quickly cover the FMLA that have more than 50 employees, the eligible employees are those that have been with you for at least 12 months and have worked at least 1,250 hours for the prior 12 months. For an employee who is pregnant, or who has adopted a child, for an employee who has a serious health condition of their own, or an employee who has needed to care for a family member with serious health. The slide that's up here just gives a few examples of what serious health condition is. To the FMLA and where employers commonly, that once you're on notice that someone is potentially out due to a serious health condition, you must give them particular notices, and these are required by statute. They need to go out within 5 days of being on notice that the employee has a possibly protected leave. The law does provide for intermittent leave, so someone doesn't need to take it in a consecutive block. Depending upon the need that's certified by the doctor, they may be able to take it in smaller increments, 1 day a week, half days, just a few hours off for medical treatments. Got to keep that in mind. If you do provide insurance for your employees, you have to continue paying for that insurance under the FMLA if you are covered. Employers can require their employees to use up any paid leave contemporaneous with FMLA leave. And if an employee comes back to work within 12 weeks, they are legally entitled to be restored to the same or substantially equivalent position. You can see this. It's very different from the obligations under workers' comp. Even if you're not covered by the Family and Medical Leave Act, you may be covered by the Americans with Disabilities Act or the Florida Civil Rights Act. And the Americans with Disabilities Act prohibits discrimination against qualified individuals with a disability, require employers to grant reasonable accommodation, which could be modifications to a work schedule, to job duties, to the workstation or environment, a different chair, a different type of stool, so long as the accommodation requested or required does not impose an undue hardship. Under the ADA, employees must still be able to perform all of the essential or core functions of their job with or without a reasonable accommodation. At all renders them unqualified. So where it's someone that cannot be relied upon attendance-wise due to their medical issue or their disability, the case law is fairly favorable to employers in saying they are unqualified for the job. Also, courts have routinely said that an employer does not have to hire extra employees or create a new job for someone. Those are not considered to be reasonable accommodations. What's important to remember under the ADA is that you're obligated to engage in a dialogue. So once you're on notice that they have a disability and that they are requesting an accommodation, you're obligated to engage in an interactive process to determine the nature of their limitations and whether there is any accommodation that is reasonable in the particular situation. You cannot simply tell someone, well, we're not going to do it. If you don't like it, leave. So as our hypothetical, you're trying to close out a month. The manager tells you she needs to miss work immediately for a medical condition. What do? Well, we've got to analyze the laws. Is the medical condition related to workers' comp? If so, if we plan on firing her, could that be perceived as retaliatory? Covered by the FMLA, if it's a serious medical condition, you may have no choice but to give her the leave. Even if you're not covered by the FMLA, if her medical condition potentially constitutes a disability, you could be obligated to reasonably accommodate that disability, and short periods of unpaid leave are frequently considered to be a reasonable accommodation. So we cannot simply refuse it out of hand. We have to go through the analysis if we're protected by or covered by any of these laws. Action Plan B, well, obviously, always ask why an employee is absent. We have the right to know. They can't just say it's a personal reason. If it's a medical reason, we don't want to know a specific diagnosis, but we want to know the nature of the limitation as to why they cannot work. We're also entitled to ask for a doctor's note or other documentation supporting their reason for not being at work. We want to analyze our obligations under each of these laws, and we want to stay in touch with that employee until he or she returns to work. We always want to have open communication so that we understand what their intentions are, and so that we're making knowledgeable decisions at every step of the way. And if it's a small business, you may want to start cross-training employees so that you're not at the mercy of one employee who suddenly has to be out of work due to a medical issue, that you have someone else cross-trained that can fill in and perform those duties in a pinch. Number 6, and I know it's 12 o'clock. I hope everyone can stay on. I know we probably didn't get started till about 20 minutes late due to the technical difficulties that we had. But item number 6, how to deal with religious issues. Important to understand that the protection for religious beliefs and practices is extremely broad under the law. Essentially, any set of ethical or moral beliefs that are sincerely held are protected from discriminatory actions. And all of those of us at Fisher & Phillips have seen some really, really wacky beliefs over the years, and in cases that people claim are sincerely held religious beliefs that the courts have upheld. And the protection is not just for religious beliefs, but also for practices, religious dress, and religious holidays. Unlike most other types of discrimination protections, the protection against religious discrimination requires accommodation. So in some sense, it's similar to the Americans with Disabilities Act. whereas the standard under the ADA is that an accommodation must be reasonable. Here, you have to accommodate unless the cost is more than de minimis. And I wish I could tell you a sort of black and white test for what is de minimis, but there's no such thing. It's always going to be evaluated on a case-by-case basis. This hypothetical, and I hear this a lot. A salesperson says you can't work on Saturdays for religious reasons. What is your response? Well, hopefully it's not just right off the bat, well, if you can't work on Saturdays, don't bother coming into work at all, you're fired. We've got to analyze this. If that is a sincerely held religious belief, we have to analyze whether or not we can accommodate that. And it may vary from business to business depending upon the size of the business, how many other people we have. In some situations, it may not be more than a de minimis cost to allow that person to not work on Saturdays and simply schedule other people in that place, or to allow that employee to find their own substitute if they're assigned to work on Saturday. In other situations with a small business, it might be too great a burden, but we've got to go through the analysis. One salesperson tells you she needs to wear clothing required by her religion, which includes a long dress. And what's your response? Well, again, we can't simply reject it out of hand. If it's a sincerely held religious belief, we need to analyze whether or not accommodating that person's religious dress creates more than a de minimis cost to the business. And a lot of times, I can tell you the EEOC and the courts have been very receptive to requiring employers to accommodate religious dress. So you never just want to say no out of hand because you think people perceive it a certain way. Typical forms of accommodation are work schedule issues, someone needing time off for prayer time or to observe the Sabbath. It could be accommodating dress or appearance issues, hair, how they have to maintain their hair or have a beard or wear certain types of veils or headdress. Other accommodation could be religious practices at work, giving someone time off or giving them a break at certain times of the day where they need to engage in prayer or modifying job duties so that they can perform their job. These are all common forms up from time to time. As managers, what should you be doing? Well, always discuss the employee's requested accommodation to determine if it's religiously based. Objectively determine the impact on the dealership. If you can't be objective, call someone else who can provide an objective point of view. I have a number of clients, small businesses that are on retainer with us. They pay us a small amount each year, and it enables them to call us with all means and manner of that we can answer in fairly quick phone calls. And those employers will tend to call us on things like that because we will generally be more objective, having a better knowledge of the law and being removed from your workplace to be able to give you some good guidance. Objectively determine the impact on coworkers, then determine if there are any alternate accommodations that can be made. The last thing that you want to do is simply reject the requested accommodation out of hand. 7, how do we deal with alcohol and drug use amongst employees? Well, there is no federal law dealing with drug testing or drug use. In Florida, the Florida Workers' Compensation Statute does provide a section with the requirements of that section of the Workers' Comp Statute may be entitled to a discount on your workers' comp premiums. So that's one reason why a lot of employers want to have a policy compliant with that particular Florida statute. But if you're not trying to get the workers' comp discount, again, there's no other Florida law putting restrictions on or mandates for drug testing. Our recommendation to employers is that you want to ensure that all applicants agree to drug testing. You want to make sure that's part of your application. You want to make sure you've got a drug-free workplace policy as part of your handbook, and that all employees agree to comply with that handbook. Make sure it's distributed to everyone, and that you have acknowledgement sheets in your files so that an employee can claim that they didn't get that handbook. Why should you drug test? Well, there's a lot of good reasons. It could help avoid hiring problem employees. As I said, it's always easier not to hire someone than to hire them and then have to fire them later. Drug testing can serve as a deterrent to drug use for a lot of employees. I'm not going to say that that's the case for everybody, but certainly, as a deterrent, it can prevent accidents and injuries by deterring employees from coming to work under the influence. It can prevent theft. It gives you a legally sound reason for terminating employees, and it can protect the dealership from negligence claims if someone is injured as a result of an employee that was impaired. There's a lot of good reasons to drug test, and I haven't heard nearly anywhere as compelling reasons to not bother. You have a policy, what should it say? Well, you want to make sure the policy that you can test for any drug, that you can test at any time. So, when we do a policy for someone, it has not only accident testing or sufficient testing, but also random can be part of your policy. Employees, pursuant to the policy, must cooperate and submit to drug testing when properly asked. Failure to do so is justification for termination. And in addition, your policy should make clear that providing an adulterated sample is also grounds for termination, that it's considered a failed drug test. Mechanics of the testing, make sure, if you're going to rely on reasonable basis testing, make sure you have a reasonable basis. The standard's not really that high for private employers. It could be the smell of alcohol on someone. It could be glassy eyes, slurring of words, being unsteady on their feet. If we're going to use reasonable suspicion, make sure we're documenting what it is that's giving that reasonable suspicion. If it's random drug testing, then it's just part of the random drug testing process. You want to meet with the employee that you're going to require them to be tested, and you want to immediately take them to testing. Don't let them drive themselves if you believe that they're impaired. That could lead to liability issues if that person gets into an accident that we thought they were impaired and then put them in a car on the public roadways. So we're going to require immediate testing, and we want to have somebody else, preferably a manager, drive them to the drug testing facility. Obviously, be prepared for excuses, threats, admissions, get admissions, get documented. If you get threats, obviously don't put yourself in peril. If someone's going to become threatening and they're refusing to go for the testing, then that's reason for termination right there. Hot item number 8, how to deal with social media. And this really is a hot item in current...
David, I don't mean to interrupt you, but I think I may be able to mute this other person. I'm going to push a code, and then if you can push *6, I believe that will mute everyone except for you.
Okay. Can anybody hear me? If you can, just pop up a message. Okay. So it seems like we've got this resolved, and everyone perfect. Okay, we're getting some yeses. Everyone can hear me, and we've cut out the background noise at least for the tail end here. And I think this is the first time FIADA has done the webinar system, so there was bound to be a few glitches. So I appreciate everyone's patience with us going through this. So as I was saying, social media has given rise to numerous harassment and discrimination claims. And in fact, the General Counsel for the National Labor Relations Board has issued, I think at this point, 10 different memoranda on social media. And the National Labor Relations Board has taken some positions on social media that have been widely criticized by employers and employment defense attorneys, where they're alleging that a company has an overbroad employer social media policy that is infringing upon protected rights, and that the policies and that employers are unlawfully disciplining or discharging employees over contents on social media posts. And really, it's a tough issue. And for employers, what we have is, we don't want anyone speaking out negatively about us. And so when employees are saying things in social media avenues that are negative to the company, our initial reaction is to be angry and want to fire that person. Unfortunately, we cannot react immediately to that and respond in that way, because the reality is the National Labor Relations view on it is that may be protected activity. Employees are allowed to engage in concerted activity with one another about terms and conditions of employment. And so, unfortunately, what we have to do is specifically look at the nature of the post. And some posts may be individual criticisms of a manager or of an employer that do not give rise to any type of protected activity. But depending upon the nature of what's being complained about and whether it's an invitation for other people that work for the company to join in the discussion, it may be protected. So before you simply terminate someone because they made a posting that you did not like, you really should confer with legal counsel to make sure that you're not making an imprudent move. So what do we want to do? We want to have a policy. It's a good idea to lay groundwork and set the limitations, because social employees should be put on notice that social media sites cannot be used in any way that their employees. We want to make sure that they're not putting themselves out as the voice of the business in a social media site unless we specifically want them to be the voice of our business. And so these are all issues that can be addressed in a properly drafted social media policy. For managers, we want to make sure that we're not creating any problems with use of social media. So obviously, don't post anything that you wouldn't want your boss or your spouse to see. Try not to friend subordinates. And the problem is, you're going to open the door to seeing a lot more information about them than you necessarily want to, which could, lead to claims that you made a decision based on a discriminatory motive. Be really careful about checking out applicants online. Some states, Florida is not one of them yet, but some states have actually, are prohibiting using social media in the hiring process, and certainly prohibiting requiring an employee or applicant to friend you and give you access to their social media site. You don't want to go where you're not invited. A lot of times you'll find out information through other means, and it may be a coworker shows you something on another employee's social media site. There's nothing wrong with that. You can't require that coworker to give you access if there are, let's say, friends with someone on Facebook. But if they're voluntarily bringing it to you, for instance, an employee calls out saying they're sick, and someone brings to your attention that, in fact, they are posting on their Facebook page while they're out at the beach. I mean, obviously, there was nothing improper about the way you learned that information, and you could take an adverse action against that employee for lying. But in general, don't go where you're not invited. If a post or a tweet involves harassment, you want to make sure that you investigate it. Instead of just being reactionary and someone posts something negative that you don't like about you or about the company, think about it. If it doesn't have a tangible impact on the dealership, it's probably not worth creating an issue. If it does have a tangible impact, then obviously you may need to take steps to address it. And last, as I said, you understand what protected concerted activity is so that you don't make decisions to fire someone and give them grounds to go to the National Labor Relations Board with a complaint. Number 9, how do we deal with poor performers? Well, there's multiple steps to this. First, ask yourself, what exactly is the employee not doing? Or that they are doing that they shouldn't be doing? And ask yourself also, what is it that you want them to do or not to do? So have a clear idea of what they're doing wrong. Next, you got to tell them. Because if you don't communicate with the employees as to what they're doing wrong, they're not having an opportunity to improve or to fix the problem. And that's depriving you of potentially a good employee that could fix those issues if they had noticed. It's depriving the employee of the opportunity to improve. And if you end up firing the person, then you've got to start over hiring and training someone new. So you want to tell them what you're dissatisfied with. You want to give them specific examples. If this is something that's a significant issue, or if it's a minor issue but it's been going on repeatedly, such as attendance, you're going to want to put it in writing. at some point. You're going to want to be specific in that writing, give specific examples, and then have the employee sign off on that disciplinary notice. And a great idea, instead of just asking for a signature, because a lot of employees don't want to sign, have them put down in writing, what their plan is to improve the issue. If they don't think there's a problem at all, then let them put down on that disciplinary write-up, why we're wrong. We really don't care whether they agree with us or not. What's important, if we can, is to try and get their handwriting on that paper so they can't claim later on that they never saw it. And so that's really the trick, getting their handwriting on the paper, whether it's a signature, whether it's a plan for improvement, or whether it's a criticism that they've done nothing wrong, because then they cannot claim later on that they didn't see that write-up. And third, if we're going to talk to them about the problem and we're going to write it up, we want to follow up with them to make sure they're doing the right thing. If they're improving, positive feedback is wonderful. It really does have a tangible positive impact on that working relationship. So if they're taking it to heart and they're improving, let them know. Thank them for improving. If not, we're probably going to have to sit down with them again, have them with another writing, remind them of the issues, the commitments that they made, and document the continuing failure. And the reason that we want to do that is going to come up with this last topic of termination, and that is that a jury will view us as having done everything that we can as the employer, rather than just being quick to pull the trigger and fire someone. We spoke with them. We gave them opportunity to improve. They weren't improving. We spoke with them again. They still didn't improve. Finally, we had no choice but to terminate. It simply makes us look good. And so that brings us to our last item, how to terminate an employee. As we talked about earlier, forget about employment at will. I mean, just about any employee can claim that the reason for their termination was discriminatory, and then flip the burden to the employer to set forth its legitimate non-discriminatory, non-retaliatory reason. So with that in mind, you always want to have that valid reason for termination that you're going to potentially have to present to a jury. Consider non-termination alternatives. Is termination the only appropriate response in this situation? Maybe it is. Maybe it's not. I get a lot of phone calls from clients. They say, I want to terminate this employee. This problem's been going on for months and years, and there's just no improvement. And I say, well, have you disciplined them yet? Have you written it up? Did you tell them about the issue? Well, we've talked to them once or twice over the years, but nothing's in writing. Well, my advice is going to be, you can fire them if you want, but I recommend that you put it in writing and get some documentation, because that documentation is key to a defense. Maybe termination isn't appropriate. Maybe it's that particular job isn't suited for them, and there's a different job that they would perform better at. Now, the caveat to that is if it's an attitude type issue, you don't just want to transfer a problem employee from one department to another. It's probably not going to improve. But depending upon the nature of the issues, consider some of these other alternatives. Select a rifle, not a shotgun. You want a reason that you can prove. As I said earlier, you always want to be honest with employees. Give them the reason. Don't give them a list of 7 reasons. If there were that many reasons, you probably would have fired them long ago. There had to have been some triggering issue right leading up to that termination decision. So you want to be clear and definitive as to what the reason is for termination, and that it's one that can be substantiated if someone challenges it. You don't want to terminate someone for attendance problems if you have 3 other employees that similarly have bad attendance. Because if that one person being let go falls into a different protected category than the others, you're going to look at a discrimination claim. You want to be consistent if you're terminating for policy violations. Do not say the generic, we're making some changes, we're going in a different direction, or you're just not a good fit. There has to be a specific, inevitably, there is a specific reason why this person is no longer suited. And so you should be honest with that person. And obviously, if it's for performance issues, it shouldn't be a surprise, because if you've done what you should have up to this point, you've already talked with this person on multiple occasions about those performance issues, so they already know. So there are two types of terminations. Poor performance is one of them. And so we've got to look at different factors. For a poor performance discharge, and we want to ask ourselves, does this person have the skills to do the job? Does he know what I expect of him? Does he know that he's not meeting my expectations? And hopefully the answer to all three of those questions is yes if we're going to move forward with termination. Next is the warning phase. Have I given him a written warning explaining that they're not meeting expectations? Did he buy into the problem? Did he agree that he must change? Did he have a plan to address those concerns? If it's yes and he's still not meeting expectations, we keep considering. Was he given a fair opportunity to improve? If it's a sales issue and you tell someone you've got to get your numbers up this month and then you fire them a day later, have they really had an opportunity to improve? Probably not. Maybe there was some other issue intervening that gives you independent reason to fire them. But we always want to evaluate that. Were we fair? Are there specific objective deficiencies, that I can explain to a jury? Can this employee dispute that they've fallen short? And hopefully where there are objective deficiencies, they may claim that's not so, but the numbers are going to speak for themselves. And lastly, once we've made that decision, we want to announce it. We want to do it in a private location. There's no sense in embarrassing the person. We never want to do it. We never want to discipline out on the floor in front of other employees or in front of customers. But certainly for termination, do it in a private location. Give them your reason and the decision. Give them an opportunity to speak their mind. Obviously, if they start getting hostile or aggressive, you're going to want to end that meeting right away. Get back any keys. If there's issues on final pay or insurance, be sure you're prepared to address them. And then, obviously, in the best way possible, escort them from the property while trying to preserve their dignity. If it's a rule violation discharge, the factors that we want to consider are going to be a little different. First, in the investigation phase, did we determine exactly what happened by talking with that employee? Did we get their explanation in a written statement? Have we interviewed and gotten statements from witnesses? These are things that we should be doing. So hopefully the answer is yes. Having investigated it properly, we've got to determine the appropriate discipline. Is it a write-up? Is it a warning? Is it a last and final, a suspension, or is it termination? We always want to ask whether others have been terminated for similar violations, because we want to be consistent with our prior decisions. Inconsistencies lead to claims of discrimination. If you're not the ultimate decision maker, discuss it with your supervisor. Will this seem fair to coworkers? Will it seem fair, importantly, to a jury? And if we're comfortable with the decision, then again, it's similar to the other one. Bring the person in to a private location, announce the decision and the reasons, tie up the loose ends, and by all means try to preserve their dignity. And that's key, because if someone leaves feeling disrespected, they're much more likely to go to a federal agency or to an attorney with a complaint and try and initiate a legal action. When in doubt, suspend and investigate. Do not terminate. Heat of the moment decisions are generally bad decisions, and so the better course of action would be an immediate suspension to give you a chance to cool down, investigate fully what is going on, and then make an educated, wise decision. Don't terminate for insubordination. I don't even like write-ups that just say that an employee was insubordinate. That's a conclusion. You want to be specific with your write-ups and specific with your reasons for terminations. What exactly did the employee do that was insubordinate? I instructed this employee to do X, Y, Z, and he refused. Well, yes, I would agree that constitutes insubordination. That explanation is a much better reason to put down in a disciplinary document or a termination document. If it's for violation of dealership policy, be specific. What policy was violated? You want to have the detail. If it's performance related, as we've said, make sure the employee has been warned. And of course, do it in private. And that covers these top issues, at least what I think is important for all managers to know going into the new year. I know we went a little long, but I know we had technical difficulties, which at least we finally did get resolved at the end. I hope everybody took at least a useful nugget or two out of the presentation. And I think if we have some questions and people want to hang out, I'll do my best to answer some of those questions quickly. If not, my email address is on the screen right now, and you can feel free to email me. Let me know that you were in the call, and I'll do my best to answer that. And of course, if there's any other questions that I can answer or assistance that I can provide in terms of preparing handbooks, harassment policies, or anything of the sort, by all means, feel free to contact me.
I have a few questions. First, I just want to confirm, can everyone hear me? Okay, great. David, thank you so much for this presentation. You were an excellent presenter. We got a lot of very valuable information, and I apologize tremendously for the sound transition at the beginning and the interruptions throughout. Thank you, everyone, for sticking with us, and we really appreciate your patience. I have a list of 6 questions that were asked throughout the presentation. If we want to go over them quickly, and then, as David said, follow up with him directly if you have additional questions.
Right, and I have no problem if you want to make the PowerPoint available to participants.
Great.
If anybody wants me to send if you shoot me an email, I will send you a copy of the PowerPoint as well. Yeah, I know some of the slides we went through fairly quickly. I was trying to make up some time along the way.
Thank you. That's very generous of you to do that as well. The first question that we got was from Brittany, and it said, is it legal to discriminate against a non-Spanish speaking applicant if we're specifically advertising for a bilingual position?
No. If the ability to speak both English and Spanish is a legitimate requirement of the job, there is no problem in obviously not considering an applicant that cannot speak Spanish. What you could not do is only consider Hispanic applicants. Because if you're simply assuming, well, if they're not Hispanic, then they can't be sufficiently bilingual, so I'm not going to consider anyone that is just American, because there are a lot of non-Hispanics that are bilingual. Mm-hmm. So the discrimination is not on the basis of being in a protected category. It's not that I only want Hispanics. It's on a legitimate job requirement of the necessity of being bilingual. And so that itself is not discriminatory.
Great. I see we have additional questions rolling in as well. Let's just try to get through a few. I know that we're over time here.
And as I said, anybody whose question isn't answered, if you shoot me an email, I will do my best to get a response to you.
Great. Another question we had is, we have 47 employees currently. Are there additional precautions or things we need to know once we cross that 50-employee line, other than FMLA?
FMLA is really the only federal statute that has a threshold that high. So with 47, you're clearly covered by all of the what I call the civil rights laws, Title VII, the ADA, the ADEA. So really, it would be the FMLA would be your biggest concern in terms of crossing that 50 threshold. Keep in mind, it doesn't. Your obligations under FMLA don't kick in immediately once you hit 50. That threshold is 50 or more employees in 20 or more calendar weeks in the current or prior calendar year. So once you hit 50, you would just start counting, how many weeks your payroll is staying above that 50, is at or above the 50 number, and obviously, if it is apparent that you're going to stay above that number, you want to make sure that you have your FMLA policy and posters in place before you get to that 20th week in that first current year.
Okay, great. Quick question, how do we handle employee complaints when customers offend them? So if an employee's complaint is that they've been offended by a customer.
Well, it depends. It depends on the nature of the complaint and what the customer did. If we're talking about customer behavior that is discriminatory or harassing, employers have to remember that you are obligated to protect your employees from hostile work environment, and whether that hostile work environment is being created by coworkers or by customers, vendors, or other third parties. And so you cannot tolerate, for example, racism by a customer. And while it may hurt to turn away a potential sale, if you have someone coming in, for example, making racist comments, a customer coming in making racist comments, your best course of action would be to bring that person aside and explain that that you don't tolerate that kind of behavior, and that if they cannot curb their conduct, that you're going to ask them to leave. Because I assure you, the profit that you would make on whatever sale by allowing that customer to behave that way is far outweighed by what it will cost you to defend a lawsuit if that person's behavior was severe or pervasive, giving rise to a hostile work environment claim by an employee.
Okay. I have two more questions that kind of go together, and I think at that point, if you have additional questions, you can just contact David directly. The last two questions that we have is, can someone require a paid religious holiday other than the ones the company normally provides? Is that a discriminatory practice from the employer? And kind of coming off of that, are you ever required to pay for holidays, sick days, or vacations?
As private sector employers, there is no obligation to provide paid time off. So the decision as to whether or not you want to close for certain holidays and make those paid holidays is entirely within your discretion. The decision of whether you want to offer paid time off to employees, whether that be paid vacation leave, sick leave, or generic PTO policy, again, is within your discretion. Can an employee demand paid time off for a religious holiday that they are choosing to observe, that they otherwise not be closed for? No. We may, if they want to use if they have PTO for that, some companies, bigger companies may also have, what they call floating holidays for those reasons. But if they have, obviously we would let them use it for that. If they're asking for the day off for religious observance, even if the dealership is open, we may need to give them that as an unpaid leave as a reasonable accommodation. But no, they would not have a basis to have the day off and demand pay for it.
Okay, well, thank you so much for sticking with us, and thank you, David, for answering all of these questions and providing such an educational webinar. And we'll follow up with an email so everyone will receive a copy of the presentation. And, as David said, you're welcome to send him an email, get in touch with other questions, and if you'd like a copy strictly of the PowerPoint, you can contact him for that as well.
Yeah, and if anybody has any feedback that they'd like to share with me, both positive and negative, I'm always open to constructive criticism. Feel free to send me an email and let me know. I always like to know how my presentations are received. And I thank you for attending and participating. And again, I hope that you found some or all of it useful and helpful to you in your working for your dealership.